Thank you very much. Now, first, of course, I will say, okay, cheers, because the name Aperitivo. So very interesting topics until now. And of course, although we are almost at the end of the 1 hour, I still need 10 minutes to say something about the rules on evidence at UPC. So I do not need much time to draw your attention to a number of the important aspects of the law of evidence on UPC. So first, so what can serve as evidence? So according to Article 53 of the UPC, the agreement, and 170 of the Rules of Procedure, various forms of evidence and ways of obtaining evidence are recognized. So among other things, the following means of evidence are permitted. So the written evidence, the electronic files, physical objects, of course also the expert reports. Of course, the expert has to be independent and objective, but also witness statements, although a written summary of the intended statement shall be filed in advance. Well, the list is not exhaustive. The provisions allow for the use of other forms of evidence, and the parties have freedom to consider alternative means of evidence. And this is significantly different from the practice in some national systems. So in contrast, for example, strict evidence systems in Germany, where only certain types of evidence are permitted, the Netherlands has an open evidence system. So in principle, all types of evidence are accepted, provided that they have been submitted by a party. And well, and this also applies to the UPC. So to my opinion, the key takeaways are, for this short summary, the UPC judge may only base his decision on grounds, facts, and evidence submitted by the parties, or of course introduced by an order of the UPC on which the parties had the opportunity to present their comments. And second, the parties are free to use any type of evidence. And of course, very important for who has the burden of proof for using that kind of evidence. In principle, the burden of proof for fact rests with the party invoking those facts. Now, how does it work? In case of a dispute, the burden of proof for infringement of the patent, as well as for all facts which establish a claim, lies with the plaintiff. Where the defendant contests that a specific feature of an embodiment fall under the claims feature of the patent, it is principle the plaintiff who bears the burden of proof. So on the other hand, the defendant has to prove the objections asserted by him, and this applies, for instance, to the plea that no infringement is given in view of existing license rights, prior use rights, as well as to the plea of exhaustion of the patent right, or, for example, the plea of the statute or limitations or feature. So which rule? 172.1 Rules of Procedure place the obligation to present evidence solely on the party that has been made the disputed factual assertion. The key takeaways are very short. The burden of proof of facts shall be on the party relying on those facts. A party making a statement of fact that is contested or likely to be contested by the other party shall indicate the means of evidence to prove it. Then, of course, what we should also reckon is that the UPC also plays an active role in obtaining an accurate picture of the facts. UPC has extensive powers to clarify facts and gather evidence. So the court may take procedural measures at any time during the proceedings, either on its own initiative or at the reasoned request of party. This may, for example, involve requiring party to take a step, answer a question, or provide evidence within a specific period. Now, an important consideration here is that the court may intervene in case of delay or failure to present evidence in a timely manner. So Rule 172.2 Rules of Procedure stipulates that if evidence under the control of a party is not produced on time, this will be taken into account in the court's decision. So All available evidence must be presented in a timely manner so that the court can issue an order for the production of evidence, the sharing of information, or the conduct of experiments. And the request for experiments according to Rule 201.2 Rules of Procedure should be submitted as soon as possible. So in summary, in the UPC, the law of evidence is not only based on the presentation of evidence by the parties, but also on the active role of the court in gathering and assessing evidence. So be prepared. So when must the evidence be available? Well, the rules of procedure require that all evidence be at least indicated when submitting the statement of claim. So since the rules of procedure adhere to a strict timetable, evidence must be prepared at an early stage of the proceeding so that it can at least be indicated. This also applies for facts that are likely to be disputed by the other party, and this requires a strategic assessment of which facts are likely to be disputed and therefore require evidence. So, for instance, if no evidence is presented in relation to a disputed fact, Rules of Procedure 171.1 stipulates that the court will take the failure to indicate evidence into account in its decision on the case, and this may lead to a negative decision based on the burden of proof. So the necessary evidence to be prepared before starting UPC action, not only the evidence to substantiate your own statements, but also evidence you need to refute foreseeable substantiated defenses from the defendant. And a court order to produce evidence must always be complied with in a timely manner. So then, what I always want to mention is, how can you also protect certain information, and in particular confidential information? And that we have also been provided by rules of the procedure. Under Rule 262A, a party may request the UPC to grant special protection to certain confidential information or evidence contained in its legal documents by restricting access to such information or evidence to specific persons only, or by prohibiting the use of such information or evidence altogether. Now, so what we know is that the UPC has issued several decisions that illustrate how it applies its rule. Now, for instance, in the case of Avago Technologies versus Tesla, the defendants requested that certain information in their defense be treated as strictly confidential and made accessible only to the plaintiff's representatives and employees who had a legitimate interest in it. Now, in this case, the defendants were successful with 2 of the 4 categories of information involved in the case, and the court ruled that this information likely qualified as trade secrets, and for that reason, it was ordered that this information be accessible to the plaintiff's representative and up to 3 of its colleagues. So, and this, to our opinion, should create sufficient safeguards to allow the lawsuit to proceed. Well, in this case, and also another decision of the UPC, they had also made a number of general statements about the application of confidentiality restrictions in the UPC. Well, first of all, the confidentiality restriction will mainly be imposed when the reason given by the applicant for the request outweigh the other party's interest in unrestricted access to the information or evidence in question. And secondly, also a general statement is that the number of persons who have access to the confidential information must not exceed what is strictly necessary to ensure the party's right to effective legal proceedings and a fair trial. And this must include at least 1 natural person from each party, as well as the lawyers or representatives of those parties. And for the takeaways for this central statement is that proportionality plays an important role in deciding whether part of the information should be withheld on grounds of confidentiality. And secondly, access to confidential information will be limited to what is strictly necessary. And that makes also very interesting a topic, of course, how to deal with attorney-client privilege information. So how does the UPC deal with this kind of questions? So what we see that the UPC recognize attorney-client privilege for confidential communications between clients and their lawyers or patent attorneys, protecting for them from disclosure in UPC proceedings as detailed in Rule 287 Rules of Procedure and Article 48 of the agreement. And this attorney-client privilege protects its advice from disclosure in UPC proceedings and the UPC Patent Mediation and Arbitration Center, and of course, provided the advice sought by a client from their lawyer or patent attorney acting in their professional capacity remains confidential and is not waived. So it should be still confidential and not somehow be made public by this patent attorney or the lawyer by other means. So that's not no longer confidential. It's very interesting discussion is, of course, how should you take care that it should be considered as attorney-client privilege information. Sometimes in practice you see that parties only refer or copy a lawyer in the emails and be able to say, well, that should be established as attorney-client privilege information. But then you should be very careful because attorney-client privilege information should also be considered such kinds privileged information if the lawyer has really supervised this information, and also be aware of this information, etc. Not only be copied as a lawyer. So this privilege is applicable to instructions given to the lawyer or patent attorney in connection with UPC proceedings, but also otherwise, and thus beyond these proceedings. But then still, the lawyer or the patent attorney should be really involved in this information process. So under the attorney-client privilege, a lawyer or patent attorney cannot be questioned or examined about the privileged material. And this is also an important protection in addition to the protection from having to disclose the privileged material itself. So for instance, if there is some witness hearings or other means of evidence to get evidence, there is still a broader protection than only the information disclosed by the information themselves. So I will now come to my conclusion. It's very short in some way, but almost within the 10 minutes. The rules of evidence within the UPC offer a flexible and comprehensive approach to evidence gathering, allowing for various types of evidence. The parties are responsible for providing evidence in a very important and in a timely manner, but the court has also extensive powers to gather evidence, which ensures an active role in the process. So I will thank you for your attention. Very short. Hopefully, if you have some questions, I'm happy